This program is called Understanding and Using Colonial Court Records. I'm Don Wilson. The English brought their form of government with them when they settled the American colonies in 1607. By the time of the American Revolution, 13 colonies were using the English court system. Studying family history in this time period requires an understanding of that system of common law. One of the first things to study is the geography of the state or colony where your ancestor lived. Learn where the earliest settlements occurred and how they changed over time. RELIC staff can help you find useful historic atlases. For example, here is a map showing southern Virginia in 1750. The heavy lines showed the outlines of counties at that time. The fine lines show the area of today's counties. In this program, we will talk about types of court records, how they are used, showing samples, how to read the old handwriting, language, and abbreviations, and what do those records have that can help you with your genealogy. From the earliest colonial history, courts have been responsible for recording land ownership, probate of estates, and general court minutes or proceedings. These are the major record categories clerks have been responsible for since the beginning. We will also touch on some other important types of court records. Although the examples used in this program relate to Virginia, the other colonies had very similar records, all based on English common law. Since these courts were doing business before the establishment of the United States, the records will not be found in federal archives. State archives are the successors of those colonial governments. Local records may be found in counties whose histories go back that far. Some historical societies may have original colonial records, and many of those records have now been published as transcripts and abstracts, which simplifies finding the records you need. Unfortunately, not every record you need will be found. Record loss has occurred because of courthouse fires, floods, and tornadoes. Records have been lost through acts of war, and in some cases, record custodians have gotten carried away while housekeeping and have deliberately destroyed records they thought were of no value. We will begin with land records. Here are 6 kinds of land records that should be looked for: land grants, deeds, long-term leases known as leases for lives, surveys and plats, land tax lists, and poll lists. A land grant is known as the first deed. It identifies the first private owner. It is issued by the colonial government or a proprietor acting on their behalf. The government may or may not have bought the land from Native Americans in the region. It will describe the land's location, its boundaries, and any neighbors. In the early years, it may be based on a headright claim. Existing records will usually be found at the state archives. Indexes or digital images may be found on the Archive's website. So what is a headwrite? The headwrite system was set up to encourage immigration to America. Each immigrant was entitled to free land. Many poor immigrants gave up their headwrite to pay for their transportation. Headwrites were a valuable commodity and could be bought and sold, though the names of those transported are usually recorded on them. The date the land grant is issued is not the date that the ship arrived. In fact, it may be years later that a grant was issued based on it, and the location of the grant is not necessarily where the headwrite lived. Groups of headwrites on a single document may have traveled on the same ship, which might be a helpful clue. Sometimes, through fraud, a group of names may have been used more than once to obtain a grant. By the early 1700s, most colonies had given up their headwrite program. Here are 4 steps to obtaining a land grant. First, one or a group of headwrites was recorded with the local court. The court gave the applicant a document entitling him to a certain number of acres. That certificate is called a warrant. When the headwrite system faded, that warrant would be based on payment of a composition fee. Next, a surveyor was hired to lay out a plat covering the land the grantee was seeking. Hopefully, it was a piece of land not already claimed by someone. Finally, the land office issued the deed to the land, called a grant or patent, which includes a description and the method of paying for it. This is a page from the Library of Virginia site, a summary of a land grant issued to Obed Calvert for 212 acres in Prince William County in 1772. This is the digital image of the grant from the same website. Software programs like DeedMapper allow us to plat a land grant or deed based on the description in the document. The surveyor lays out the parcel systematically following its boundaries. This is called a meets and bounds survey. It tries to show exactly where the land was located. It intends to begin with an identifiable point, though in many old deeds that point may be hard to locate today. The compass direction and distance take you to the next point. The unit of measurement in the colonial period was called a pole or rod, equivalent to 16.5 feet. Typically, adjoining neighbors are mentioned, which can be helpful in locating a tract. Once the boundaries are drawn, you may place it among neighboring tracts. Before software was developed, it was necessary to use a ruler, protractor, and a calculator to draw such a survey. The software will allow you to quickly see an outline of your parcel of interest. Here is the survey of Obed Calvert's land, showing all the corners and lines. Often an oak tree marked the point in a line. Most of those trees have disappeared over the years. Here is Obed Calvert's grant again, surrounded by other grants that have been put together like a jigsaw puzzle. You will notice the boundaries do not always match. This collection of plats was compiled by a former RELIC volunteer named Charlotte Kane, who did us a great service. Here is the same collection of plats, this time identifying the boundaries of Obed Calvert's tract. The next kind of land record is the ordinary deed, in which land is sold from one private owner to the next. The seller is called the grantor. The buyer is the grantee. These are the terms used in the deeds indexes. A deed may be recorded at the local court or at an appellate court. It should include a metes and bounds description of the property. Sometimes, however, the seller is lazy and just refers back to an earlier deed. This is frustrating when the earlier deed is missing. During colonial times, the deed may be in two parts, a lease and release. The lease puts the property in the hands of the buyer. In the release, the seller gives up all claim to the land. The wife of the seller has a legal interest in the property called a dower claim and should be involved in the release. Each document should be witnessed by 2 or 3 people who often are friends of the parties to the deed. Here is an image of a deed taken from microfilm. You can see it is not as clear as we would like. The grantors are John and Elizabeth Canterbury. The grantee is George Harper. This is an abstract of the same deed. It does not provide every measurement of the boundaries, but it gives a summary of the provisions with all names mentioned. When beginning your research, abstracts like this can be very helpful, allowing you to understand the document without having to decipher it. Many abstracts I am showing you today are from the hands of Ruth and Sam Sparacio and are some of the best. A deed of gift like this often will identify relationships. Here, Wharton Ransdell is giving land to his sons named Wharton and William. Prince William County lost many records during the Civil War. An index prepared in 1827 is especially important because it tells what was in some of the lost deed books. If your county has lost records, be sure and look for indexes like this. A particular form of deed during the colonial period is a lease for lives. The land is not released or sold to the tenant. Instead, the owner lets the tenant, and usually 2 members of his family, live there for the rest of their lives by paying an annual rent. Often such a lease is signed soon after the tenant marries and has a child. After they all die, the land reverts to the landlord, although the tenants are allowed to sublease the land during their lifetimes. The landlord continues to own the land and pay real estate taxes during the life of the lease. Here is a 1746 lease of land along the Rappahannock River from Peter Hedgeman to Joseph Delaney. Notice that this land is now in Fauquier County, although before 1759 it was in Prince William. This lease is for the lives of Joseph Delaney and his two sons, William and Charles. The tenant can pick any three persons to be parties to the lease, whoever he thinks will provide long-lasting security for their home. This deed from 1741 is a division. It identifies the children and heirs of Henry Halley and tells how their shares of the land became the property of James French and Leonard Hornsby. Apparently, after a number of years, they are finally agreeing to draw a dividing line, which is described in this deed. Here is a poll or voters list for the election of burgesses in 1761. These lists are usually found in deed books. There was no secret ballot in those days. Everyone on this page voted for Colonel John Bayliss. The reason this is a kind of land record is because in order to vote, you needed to own or control at least 50 acres of land. A person with a lifelong lease was eligible under this rule. Next, we turn to probate or estate records. They include wills, administrations, inventories, accounts, and divisions. Here are terms you need to know. The testator is the person who writes a last will and testament. The executor is the person who carries out the will's provisions. A female is called an executrix. If an executor is not named, or if a will is not written, an administrator or administratrix is appointed by the court to settle the estate. Probate is the act of settling an estate. Intestate means the decedent left no will, and a nuncupative will is an oral will that is reported by witnesses. Here is the will of Scarlett Hancock, filed in 1740. He divides his land and personal estate between his wife and two children. He names 13 slaves and tells their fates. A will is one of the most important documents for identifying people in a family, but it doesn't tell the whole story. The two children are apparently very young, and we need other records to see what became of them. They would not be able to sell their inheritance until they came of age. When an executor or administrator accepts the responsibility for settling an estate, he or she usually must file a bond protecting the estate from embezzlement. The principal on the bond is usually the widow, heir, or chief creditor of the estate. That person is supported by two co-signers or securities, who are often relatives or creditors. The amount of the bond indicates the approximate size of the estate. Both these estates had bonds for £50, not particularly large for that time. The next step in the process would be for the court to appoint 3 disinterested men to appraise the personal estate. including slaves, livestock, tools, and household goods. Here's an inventory from 1797, which still uses the British monetary system. The slaves are identified by name. Some inventories may give their ages and relationships. The value given an enslaved person may provide a clue to their approximate age. An estate sale auction often takes place to allow the value of the property to be divided equally among the heirs. If the sale bill is recorded, it will show each purchaser what was bought and what they paid. In this estate sale dated 1800, in among the livestock and tools, one Negro boy, not named, was sold for 40 pounds. One Negro girl named Minot was sold for 57 pounds. Hopefully, the boy's identity can be proved by other records. Finally, the administrator or executor would record all the collections and payments made for the estate, giving you insight into what was going on in the family or business. In 1737, George Mason of Gunston Hall was an orphan. His father's estate account shows monies paid for quit rents, schooling for young George, and for defending the estate in court. Court orders or minutes are the third great category of documents found in colonial courts. The terms are sometimes used interchangeably, but they are not exactly the same. Minutes are generally the rough notes the clerk takes while court is in session, telling of each action in a brief manner, often filled with abbreviations. Orders is the term for the actions of the court written in a formal manner and replacing the rough minutes. Sometimes both forms survive, often only one or the other. This is a page of abstracts of what appear to be orders of the court. A wide variety of actions are reported. Court orders and minutes generally show the widest variety of activities of the residents. This page tells of guardians being appointed for orphans. Note that Thomas Chambers was allowed to choose his own guardian, which indicates he must be over age 14. In contrast, orphan Thomas Young must be under age 14, since he was not allowed that option. Other matters are recording of a deed, receipt for an estate, discharge of a debt, appointment of a constable, appointment of an administrator, and granting of an ordinary license. An ordinary was an inn providing regular meals at a fixed price. Here are more examples of court activity. Appointing someone to keep a public road in repair. The church wardens are binding out a base-born child. Reports of men who captured runaway slaves, asking to be reimbursed. And a petition from citizens asking that the property tax rate on slaves be reduced. As part of prosecuting lawsuits, the court often took depositions of neighbors who were knowledgeable about the case. Such depositions can be full of local history and genealogical detail. In 1785, George Salmon, aged about 70, identifies long-forgotten boundary markers. John Somers, aged 92, takes his life story back to the year 1715. Now let us take a few minutes to talk about the handwriting of these old documents. By 1772, when this document was written, English handwriting was very much the same as it has remained into the present century. Some abbreviations may be unfamiliar, but can be deciphered by the help of a dictionary or the RELIC staff. You should be able to read this 1749 document with just a little practice. A few differences include lowercase e has a backwards loop, making it look a little like a 9. The double S resembles the letter P. Lowercase c may resemble an R. Getting to a document written in 1702, the flourishes require more study to make out the words. Small characters that don't extend much above or below the baseline are difficult to tell apart. The special letter called a thorn, that is similar to a Y, is often used to spell words that use a TH. By the time you get back to 1662, you may think the penmanship looks like chicken scratches. This writer is especially difficult because the reproduction is poor. Fine lines fade away and thick lines are blotched. Nevertheless, with some practice and with the aid of handwriting handbooks, you may be able to figure it out. Part of the difficulty with early writing is the use of unfamiliar abbreviations. Sometimes our staff can help you figure it out. Here is a document dated 1637. You may be surprised to see that this is not too hard to read. That's because what we have here is a transcript of the original record book made in the 1700s. If records from the 1600s have not disintegrated, it may be because a clerk 100 or 200 years later copied them over. During the colonial period, letters I and J were one letter. Likewise, U and V were written the same way. The letter S was written to resemble a lowercase f and called long S. It was written between low letters. Letter E is often confused with O. Lowercase c is often confused with R. Tall letters like B, T, F, and long S may be difficult to tell apart. These are just a few of the challenges you'll find in early American handwriting. Capital F is two lowercase f's written together. I have already mentioned how the Old English character called thorn is often confused with Y in words like the, that, there, and then. A curiosity you may run into is the number 8 written on its side so that it looks like an omega sign and may be confused with 2 zeros. A special symbol today, often called the paragraph mark, was used as an abbreviation in many words replacing the first syllable in words such as parish, present, provide, and replacing the word per as in percent. You will often find DO in inventories, which is an abbreviation for the word ditto. Here is a sample list of names and numbers from 1723. You can see the double F in French mason. You can see the long S in the name Dade Massey. Truncated words skip some letters. The final letter is raised over a dot. See, for example, Thomas Matthews, Benjamin Massey, Widow Martin, and TOBO, tobacco, at the top of the third column. Here are more examples from a 1724 tax list. The first three names are surnamed Bridwell. The third person of that group is John, abbreviated JNO. In the third family, we find Richard Frister and Richard Frister Jr., spelled with double F. Reading another section from the same list, we see Thomas Smith at home at Joseph Chapman, Richard Parker, Leonard Knight, Christopher Knight, spelled Xtopher. The X represents the Christ syllable in Christopher. Ephraim Knight, Isaac Knight, and William Murphy. Some words are easily read, others not so much. With that, we bring this workshop on colonial court records to an end. I am happy to have provided some tips to help you get started. Please ask the RELIC staff for help with your individual research needs.